Your Honor, my secretary stepped out of the office for a few minutes, I guess, to go to the post office, so I don't have them, but I'm.
You're, it, it,
No objection, Your Honor.
Your Honor, I don't have the dates in front of me, but Mr. Sansbury and Mr. Sansom have been in the case. Well, Mr. Sansom just got admitted pro hack a few days ago. But Mr. Sansbury has been on the pleadings, as have I, from.
during the, Your Honor, first, I've pulled up the docket from Peach Corps, which I think I can share with you, that has the various filings on it. Give me a, yeah, sure. You can see that, okay. So here's, the hearing took place some in December of 2020. And then you see, yeah, Mr. Be correct. And then I entered appearance February 8th. And then here are the motions admitting Mr. Morris and Mr. Sansom. Yes, sir. They had not hired counsel at that point in time, Your Honor. The file was being administered by Crawford and Company, which is a third-party administrator, and they were in communications with Mr. Brown and Mr. Collier at that period, at that point in time.
Your Honor, I just wanted to say that there's no violation of Rule 3.3 because there's no judge shopping. The transfer or the assignment between you and Judge Prather is absolutely appropriate under either under both 3.3 and 4.7. 4.7 says if a matter is presented to one judge, then the attorney needs to tell the second judge that he's presented the matter to the other judge. Well, this was something that was arranged between you and Judge Prather. Mr. Buchanan cites the Horn versus Shepard case. That's not on point here. In that case, one judge said, would you handle this recusal hearing for me? And the second judge did that. Where the judge went too far was he then heard a motion for sanctions and entered sanctions, which was beyond what he had been asked to do by judge number one. In this case, it's our understanding that Judge Prather asked you to handle the default hearing. That's what he did. He didn't do anything beyond what you asked him to do. So we don't see any violation of the uniform state or superior court rules in the way this hearing came about.
Thank you, Your Honor.
Thank you, Your Honor.
Well, I think in light of Your Honor's ruling, I don't know that there is anything to go forward with today. I mean, I'm certainly prepared to hear all of the motions, but and to respond to them, but I don't know that there is anything that we particularly need to address after the ruling that Your Honor just made.
I guess I have a question about that, Your Honor. I think there are two aspects under the rule. Under Rule 60, you can move to set aside the default judgment, and it sounds like Your Honor has granted that motion. And then under Rule 55, you can also move to set aside a default once it's been taken. Is Your Honor intending to reopen the default under Rule 55 as well?
Mr. Buchanan, Jerry, what are your thoughts about that? Do we need to talk about this?
Well, Mr. Sansbury was going to argue that issue for us. So, Michael, what's your thought?
Well, Your Honor, I think if you're inclined to allow us to re-argue the motion or the default motion at a later date, I think we'd be fine with that. Yeah, well, I think, Your Honor, the motion to open the default judgment essentially has the same circumstances in that the default was actually entered by Judge Prather. And so I think what you're saying is that you're going back to before that happened so that the motion to default is pending. I don't think we've had a chance to actually address or respond to a motion to default versus filing our own motion to open the default, if that makes sense. So we would like it. Well, no, I think it's different because we're now in a circumstance where the defendants have actually entered an answer, or at least they have an answer pending in the record. And so I think the arguments about whether the default should be entered or not are a little bit different than the arguments that are under Rule 55 about reopening the default.
I do.
Yes, Your Honor.
Yes, sir. I would say 30 days. 2 o'clock is fine, and the 20th is my preference.
Both dates are good for us, I think, aren't they?
It's good for me.
They
Yes,
are.
sir. So 2 o'clock on the 20th is great for us.
I'm sorry, Your Honor, is it the motion for entry of default or for default judgment that's going to be heard on that day?
Motion for. Okay. Understand.
I'm sorry, Your Honor, I'm still confused because I think there are two aspects of it. One is the entry of default. And then once that's done, there's a hearing on the default judgment, the amount of the damages. Are we hearing the entry of default question about whether the untimely answer puts the defendant in default, or are we hearing the damages once we're placed into default? Okay. Okay. And all right. And if, I'm sorry, one more question. If the default, if you grant the motion for default on May 20th, would you then immediately proceed to a damages hearing? Is that the intent, or would that be set at a later date? Okay, thank you. Okay, thank you, Judge. Just want to make sure we're prepared.
Judge, this is Jerry again. In the ensuing 30 days, can we engage in some discovery about what kind of injury he has?
I'm sorry, Your Honor, would you repeat that for me, please? If the defendant, well, my understanding is that once a party is in default and is not timely answered, they have to be willing to announce ready for trial in stanter and defend against whatever evidence is put up at that trial without discovery. That's my understanding. Okay. I understand where you're coming from, Judge.
Yeah, as I understand the rule, we must announce ready for trial, but that does not prevent us, I don't believe, from doing discovery between now and the time that the trial is scheduled. So it's not as if we were here today and there's going to be a hearing on the default judgment amount or on the default judgment itself. So as I understand it, there is no default judgment in place at the moment, but there's our motion to open the default. Let Mr. Sainsbury address that.
No, I think, Jerry, that the motion for default is pending. So the default has been reopened, and now it's as if the motion is pending and we have an opportunity to respond to that.
Okay. So
Well, Judge, I believe you're correct, with the exception of an answer has now been entered in the case. But yes, at the time the motion for default was filed, no answer had been filed. I think I understand. Jerry, are you?
well, I think we're plowing new territory. So on the 20th of May, we are going to appear either in person or on Zoom before Your Honor. And I guess the plaintiffs will ask that a default be declared, and ask for a default judgment, and will present evidence as to the amount of that, as to the injury of Mr. Denny and his lost wages and all that. And I'm assuming we get to cross-examine him or the witnesses they put up, whoever they are.
Okay.
And again, you are not allowing us to do any discovery, like deposing his doctors or him about his injuries. I don't know the answer to that.
Not in a case that I've been involved in.
Yeah, and Your Honor, this is an issue that we didn't address in our briefing. Obviously, we're in a new procedural posture. If the defendants determine that there is a basis for seeking discovery from the plaintiffs or for the court ordering discovery, we'll file a motion with the court to that effect. Yes, sir.
No, sir. I just want to thank you for your time this morning and your courtesy, and we appreciate it. And we're glad to be with you. Yes, sir. Thank you very much.
Yes, sir. Thank you, Judge.
Thank you, Judge.
Thank
I'm
you, Your
sorry,
Honor.
wait, before we go,
Oh, yes.
Mr. Buchanan requested my presence today. Are we going to split the fee for today?
We are.
Okay.
Yes,
Does
sir.
anybody want a copy of this hearing?
I do.
We'll
Yes,
take a
sir.
copy. Yes, please.
Okay. All right. Sounds good. Thank you.
Thank you all.
Okay, thank you, Mr.
Thank you.
Goodbye.
Thank you, Judge.
Judge.